Hello everyone, this is Mehak Agarwal from Vinod Kothari and Company, and today's topic is one of the crucial discussions, that is, can NBFCs qualify as small companies? Now, before I delve into the discussion, let us first understand why this question arises in the first place. So, what are small companies? Small companies are companies whose paid up share capital does not exceed 4 crore and turnover does not exceed 40 crore. These companies have been given several exemptions under the Companies Act, whether it be exemption from holding 4 board meetings in a financial year, exemption from rotation of auditors, exemption from appointment of independent directors. But the two most crucial exemptions available to small companies under the Companies Act are exemption from dematerialization of shares and exemption from CARO reporting. If we see the definition of companies, of small companies under the Companies Act, we'll see that companies governed by special act have been specifically excluded from its purview. This means that a company formed or governed under a special statute cannot be incorporated as a small company. Now, having said that, I would now like to move on to what is meant by governed by special act. In the Halsbury's laws of England, companies were formed under a special charter or a royal charter. Over time, the Companies Act became the governing law for all companies in India, and therefore, the mention of governed by special act at various places under the Companies Act refers to these companies formed under this royal charter. The intention of mentioning them was to provide an exclusion to these companies because they were not incorporated under the Companies Act, but under another special act, that is the royal charter. Now coming to the question that we are going to discuss here. Can RBI be considered as a special act for NBFCs? Here, there are several points to discuss. Firstly, if we see the definition of NBFC under the RBI Act, it states that an NBFC is required to first be a company under the Companies Act. This means that NBFCs are nothing but companies incorporated under the Companies Act. Given the nature of the activities that they are engaged in, that is, investing and financing activities, their function was brought under the purview of the RBI. This, however, does not mean that the RBI becomes a special act for NBFCs. In fact, if we see, NBFCs are regulated and are under the oversight of various other authorities. Say, for instance, an NBFC which is acting as a corporate agent is regulated by the IRD. At the same time, NBFCs carrying out investment advisory activities are regulated by the SEBI. In each of these cases, to say that IRDA, SEBI, or RBI becomes the special act governing NBFCs would not be the correct understanding. In fact, if we also see, there are various sections and provisions under the Companies Act, say, for instance, the deposit section or section 186, which have specific mention of non-banking financial companies. Therefore, if the intent of law was to specifically exclude NBFCs from the purview of small companies, the same would have been explicitly mentioned in law as it has been mentioned in case of other sections. At the same time, there are various provisions for which the RBI directions provide a stricter requirement. So if the intention of law was to exclude NBFCs from the purview of small companies, the same would also have been provided by RBI itself. Therefore, denying NBFCs of the exemptions otherwise available to a small company, despite the fact that it meets the thresholds that are applicable to a small company, would not be justified. Hope that this discussion helps. Thank you.